Hello, I'm Alex Layton. This is the second of two talks I'm giving for the European Civil Law Observatory on the Brussels I regulation. In my first talk, I discussed the scope of the regulation and the jurisdictional provisions in it, and in this talk I'm going to look at the recognition and enforcement provisions in the regulation, one or two of the other additional details at the end of the regulation, and then look at proposals for the reform of the regulation which are going through the legislative process at the moment. The underlying principle of the Brussels I regulation is the principle of mutual trust. This model of international regime for the recognition and enforcement of judgments is based on a so-called double convention in which jurisdiction is regulated as well as recognition and enforcement. Now, the reason for this is that it enables a court which is called upon to give recognition or enforcement to a foreign judgment to avoid having to consider whether the court of origin was a court of competent jurisdiction. You have uniform rules that apply to all courts within the regime, and then they don't question each other's jurisdiction. And that is, in principle, the basis on which the Brussels I regulation operates, although, as we shall see, there are some exceptions. Now, the Brussels I regulation provides as a starting point for the automatic recognition of a judgment given in another member state without any special procedure being involved. And again, there are some exceptions, but we'll come back to those. An interested party may, however, apply for a decision of the judgment to be recognised, and equally an interested party may apply for an order for the enforcement of a judgment given by another member state. An order for enforcement is a declaration of enforceability, often referred to by the Latin phrase exequatur. And the same procedure applies to both sorts of applications, an application for declaration of recognition and an application for exequatur. First of all, the application is made by the interested party, usually the judgment creditor, to the appropriate court in the member state where he wants to obtain recognition or enforcement. And what is the appropriate court or kind of court is set out in Annex 3 to the regulation, where a list of the courts in each of the member states that entertain these applications is set out. And the application must be accompanied by a copy of the judgment which satisfies the conditions necessary to establish its authenticity. That is to say, the conditions under the national law of the court of origin. If the application is not just for recognition but is also for enforcement, the applicant must produce a certificate. And this is a certificate which he obtains from the court or the competent authority of the court of origin, of the state of origin, which sets out details, some basic details about the names of the parties, the court which granted the judgment, the authority that is giving the certificate, the date when the proceedings started, and so forth. And that's in a standard form, which of course is reproduced in all the different languages of the European Union, and so even if it comes in a foreign language, a court will be able to recognise what is being said in which part of it. And the state addressed can require a certified translation of the judgment and indeed of the certificate if need be. If the correct certificate is not submitted, the court of the state applied to can either set a time for its production or can dispense with the production of the certificate altogether, so it's not a mandatory requirement. Now, once these documents are lodged, the court applied to must, and the regulation uses the word shall, declare the judgment to be enforceable or capable of recognition, without any review of the various bases on which recognition may come to be refused. And at this stage, the party against whom recognition is sought is not entitled to make any submissions. It's a purely ex parte procedure. Now, once the court has made its initial decision, it brings that decision to the attention of the applicant, and two things then happen. Firstly, the applicant is free to take enforcement measures, but only measures that are limited to provisional measures, and indeed the court can order that security be given for any measures that are taken. And secondly, the decision on the application and the judgment, if this has not already been served, is served on the party against whom enforcement is sought, the judgment debtor. Now, at this point, the judgment debtor can raise his objections. He does it by what's called an appeal, although it will in fact be the first opportunity he has to make submissions to the court of the member state where recognition and enforcement is sought. And he can challenge the recognition or enforcement if he brings his appeal, as it's called, before one of the courts listed in an annex to the regulation. And equally, in the unlikely event that the applicant has failed to persuade the court or to get from the court an order for the enforcement or recognition of his judgment, he too can bring an appeal at this stage. And the time for appealing is set by the regulation. It's quite strict. There's no extensions permitted on the grounds of distance or otherwise. There's 1 month from the date when the decision is served, or 2 months if the judgment debtor is appealing, who is appealing is domiciled in another member state. There are a number of grounds on which recognition can be opposed. The first is as an exception to the rule that the court addressed is bound by the decision on its jurisdiction by the court of given by the court of origin. As an exception to that principle, the court address can examine whether and indeed must examine whether the assumption of jurisdiction by the court of origin was in breach of the specialised rules relating to insurance, consumers or individual employees, or whether it is contrary to the rules on exclusive jurisdiction in Article 22, which I described in the earlier lecture. Now, subject to that exception, the jurisdiction of the court of origin may not be reviewed, even on public policy grounds. Secondly, recognition is to be refused if one of 4 criteria is satisfied. Firstly, it's to be refused on the grounds that recognition is manifestly contrary to the public policy of the state addressed. And the word manifestly was introduced to make clear what had already been established by case law, that the concept of public policy permitted as a basis for refusing recognition is much narrower than the francophone and other continental legal systems concept of ordre public. In particular, it is not a sufficient public policy ground to refuse recognition that the court of origin applied a system of law which is different from that which would have been chosen by the conflict of law rules of the state addressed at the time of recognition and enforcement. The second of these bases on which, the second of these criteria which must be satisfied is that in the case of a default judgment, if the defendant was not served with the proceedings in sufficient time or in a sufficient manner to enable him to arrange for his defence, unless, and this was a new provision in 2000, unless he failed to challenge the judgment in the state of origin when it was possible for him to do so. And the third and fourth criteria are that the judgment is irreconcilable, firstly, with another judgment given between the same parties in the state addressed, and secondly, or the fourth criterion, if the judgment is irreconcilable with an earlier judgment given in another member state or in a third state which satisfies the conditions necessary for its recognition in the state addressed and is between the same parties on the same cause of action. In its examination of the appeal against the initial decision, the court is not able to review the judgment as it was originally given as to its substance, and it's bound by the findings of fact of the court of origin. There is no revisiting of the merits of the claim. If an ordinary appeal has been brought in the state of origin, the court of the member state where recognition is sought may stay its proceedings, presumably while that appeal is dealt with. And I should, of course, have mentioned that a judgment can only be enforceable in another member state if it's enforceable in the state of origin. So if its enforceability has been reversed or if it's been suspended, you never get to the point where the judgment can be enforceable in another member state. And in practice, that does sometimes give rise to a basis on which the enforcement of a judgment can be opposed. On the hearing of an appeal against the recognition or enforcement of a judgment or against the refusal, a party may not rely on evidence which it could have brought before the court of origin. So it needs to be new evidence or evidence which could not, by the exercise of reasonable diligence, have been obtained before the court of origin. The judgment given on a first appeal of this sort can be contested, but once only, by a further appeal of a kind listed in another annex to the regulation, which are basically appeals in cassation in those systems that have a cassation, a Rechtsbeschwerde in Germany, or by an appeal on a single appeal on a point of law in the Anglophone systems. A few individual points. The recognition and enforcement provisions of Chapter 3, which is what I've just been describing, of the Brussels I regulation, apply also to authentic instruments and to court settlements. Authentic instruments are documents, enforceable titles such as enforceable notarial deeds. There are then a number of detailed rules to deal with, for example, minor differences between the different legal systems of various of the member states, and to the relationship between the Brussels I regulation and other instruments. There are also transitional provisions. The other instruments may be other instruments of European Union law, which themselves contain jurisdictional rules, or they may be specialised international conventions to which member states, or now the community itself, the European Union itself, are or is a party. And the general rule is that priority is given to the specialised rule over the rules of the Brussels I regulation. The regulation also provided for the Commission, the European Commission, to carry out a review of its operation some 5 years after it had come into effect. And in fact, that review has been undertaken. It took rather longer than 5 years, but a very far-reaching public consultation was undertaken, and studies and analyses, at the end of all which the Commission produced a draft revision to the Brussels I regulation. It's called the recast proposal. And that is now going through the legislative process. And of course, the legislative process now, since the Treaty of Amsterdam, and particularly since the Treaty of Lisbon, involves a co-decision between the Council and the Parliament. And the Parliament plays a much more significant role in the legislative process than was previously the case. The Parliament, through its Legal Affairs Committee, has taken a close interest in this revision and can be expected to bring forward proposed amendments to it. And there will then have to be a negotiation between the institutions which will result ultimately in a final revised version of the Brussels I regulation. And what I propose to do is just to identify one or two of the key areas that the Commission is proposing in its draft regulation that should be reformed. And I don't propose to go into the fate of those proposals, which is not yet known, but some of them have been the subject of proposed amendments in the European Parliament. Firstly, and this is not a particularly controversial proposal in itself, the Commission proposes the abolition of exequatur. That is to say, the further simplification of the recognition and enforcement process, the abolition of the opportunity to oppose recognition and enforcement in the state addressed. That, as I say, is not particularly controversial. What is controversial is whether there's to be any basis, any exception to it. There is a body of opinion which takes the view that there needs at least to be an opportunity for a judgment debtor to go to his own courts rather than to the courts of origin to raise a limited class of objections such as grounds of public policy. The second area that I want to mention of proposed reform is dealing with the exclusion of arbitration. In the light of the European Court of Justice's decision in the West Tankers case, it's apparent that courts of one member state may be called upon to resolve a dispute between parties where one of the parties contends that the dispute should be resolved by arbitration, for example, in another member state. And under the present regulation, the court can consider whether or not that application is well founded, and there is no role for the courts of the seat of the arbitration to take that decision once proceedings are on foot in another member state. And so what is proposed is that priority should be given to the courts of the seat of the arbitration to decide that question, and that the proceedings in other member states should await the outcome of that decision on arbitrability. The third topic I wanted to mention is the reversal of the priority rule in lis pendens. In the first lecture I identified the strict rule that any court other than the court first seized must stay its proceedings in favour of the court first seized, and that was true even if it was not chosen or not perpetually chosen by an exclusive jurisdiction agreement. What the proposed revision would do is to say that courts other than the chosen, purportedly chosen exclusive jurisdiction court should stay their proceedings until such time as the latter court has ruled on the validity and applicability of the jurisdiction clause. And then fourthly, I want to mention a proposal that the Brussels I regulation should be extended to the international legal order. What this means is that, as I explained in the first lecture, the current rules apply as against defendants domiciled in member states. There are a couple of exceptions dealing with exclusive jurisdiction and with jurisdiction agreements. But in principle, they don't operate to define within the member state the circumstances in which jurisdiction may be accepted against a defendant domiciled outside the member states. And the proposal would abolish that. It would provide a uniform set of rules, not only in respect of defendants domiciled in member states, but in respect of defendants domiciled anywhere in the world. And there are a couple of proposed adjustments to the regulation which are partly related to that. Firstly, there's a rule introduced to resolve conflicts where there are parallel proceedings in a member state and in a non-member state, not quite the same rigidity as applies as between the member states, but a more flexible rule enabling proceedings in a member state to be stayed in favour of the courts of a third state. There is not in the proposal at the moment an equivalent rule to allow effect to be given to a jurisdiction agreement in favour of a third state. The view has been taken, and I've been among those strongly arguing this, that is a deficiency in the proposal. The counter-argument is that once the Hague Choice of Court Convention comes into effect, that will deal with the problem. To which my response is, firstly, well, it's not in effect yet. Only Mexico, of all the possible countries, has so far ratified it, and in any event, it doesn't cover all the same subject matter as the Brussels I regulation. Equally, there's no rule relating to the close connecting factors that within the community justify exclusive jurisdiction. So, for example, there would be no opportunity to stay proceedings in favour of a third state which concern rights in rem in land in that third state, and that's an unsatisfactory omission. Another adjustment is the welcome introduction of two rules which allow jurisdiction to be accepted in the absence of other jurisdictional bases within the European Union. Firstly, on the basis of the presence of property in a member state which has a sufficient connection with the dispute, and secondly, as an exceptional rule, in exceptional circumstances only, if substantial justice cannot be obtained in a third state where no other member state has jurisdiction under the other rules of the regulation. Now, as I say, some of these changes are controversial. They have been the subject of some proposed amendments in the European Parliament. Those amendments have not yet been put to the vote, and even if they are accepted as draft amendments by the European Parliament, it's by no means clear that they will be ultimately in the ultimate regulation. There's a lot more negotiation that needs to go on between the institutions of the community before we know the final shape. What is clear is that the Brussels I regulation will, within a relatively short period now, be reformed to carry some of these reforms into effect, and we'll look forward to see that in due course. Meanwhile, that brings my examination of the Brussels I regulation to a close, and I hope you found it useful. Thank you very much.